For more on this, I'm joined by Robert Brauneis. He's a professor of law and co-director of intellectual property program at George Washington University Law School. It's good to see you.
Thank you.
So, tongue-in-cheek a little bit, because first of all, I didn't know that the song was owned by an organization, and then I didn't know this lawsuit was so serious, but it is. Millions of dollars are at stake, and we talked just a moment ago. Is it the song or that is copyrighted, or the words? And May alluded to that a little bit.
Right, so Warner Chappell has never claimed that it owns the tune by itself. We know that that has been out of copyright since 1949.
So we're free to hum it.
We're free to hum it.
We can hum it.
But you know, if you want a movie or a television show in which you have an authentic birthday scene, people don't hum happy birthday to the guest of honor.
And is that why when you watch movies, you often hear the words all switched around, and sometimes the tune is different? So who's to judge that it was the happy birthday song or not the happy birthday song?
Well, a court would have to end up judging that, and if it was too similar, even if it wasn't exactly the same, the court might still find that it infringed the copyright in the song.
You know, the song aside, there are other songs that people use. I mean, we use songs, we use music all the time, even in our show, but I mean, I know it's a different criteria. Where do you draw the line from marketing songs, if it's just a few lines of it versus the entire song, or is there a clear definition?
There is no clear definition. The standard is called a fair use standard, and that's a very vague standard which can't really be determined by a bright line rule in advance of a particular case. You want to use as small a portion as possible if you're unsure about it.
So you and I can hum any famous song we want and we will not get in trouble. Can I say that?
No,
we can't hum it.
I said that for the Happy Birthday song in particular, that melody has been out of copyright since 1949. But there are many melodies that are still under copyright, independently of whatever lyrics might be attached to them. So if I hummed a current hit, I still might be liable.
And in this day and age, and you probably remember companies like Napster, for example, that used to share music over, and that was, of course, hugely controversial. Now it's all changed, right? You can go to iTunes, you can download music, you pay for it, you pay your fair share. Where are we now with the sharing of copyrighted material? Is it under control, or is it so big now we just stop talking about it?
Well, I think that depends upon the kind of copyrighted material. With music, it's still very difficult. There's lots of sharing going on, very, very hard to control. There are certain other types of copyrighted material where I think that owners have some more control. For example, video games. If you run an online multiplayer video game, you, the company that owns the video game, controls the server on which all of those people interact.
So it's online, they can find you, basically.
Right. And with a motion picture, maybe you can offer viewers an experience of a 3D big theater experience that they can't get with a file that they've shared at home. But with many other types of material, it's very difficult.
Okay, let's say you use a law book in your class.
Yep.
And I download it. It's great. Now, I can either share the PDF file or this file with all the other students in class, and I charge them all a $10 fee, or I could print out hard copies of it and give it to them as well. Is there a difference?
No, I don't think there's a difference.
Have I done something illegal? In
terms of copyright, in both cases, you've done something illegal. That's absolutely right.
And how do the companies, how are they going to catch me? How are they going to catch these perpetrators, so to speak?
Well, in many cases, they don't catch many of them. But there's a certain amount of leakage that you can tolerate and still make money, right? So if you're leaking, 5–10%, you're still making money. If you're leaking 90–95%, then you're in real trouble.
Globally, we talked earlier about the UK and China, but all over the world, intellectual property rights has always been a concern for a long, long time.
Absolutely.
And it seems like there's no clear agreement as to how to properly battle it, because I think there's the one issue of stopping it from happening and then also enforcing it and sending people to jail. Which one's harder?
I'm not sure the differences between sending people to jail and what?
Well, stopping people from actually even doing it in the first place.
Oh, I see. I see. I think they're both difficult. I think that people need to become a little more aware of artists and the time that they've put into creating works. And so there needs to be kind of general consciousness raising or educational effort. But for the really large ventures that engage in copyright infringement on a massive commercial scale, then I think, in very rare instances, jail time or at least a very large fine is appropriate.
Who knew that this Happy Birthday song would lead us to talk about this topic? Professor, good to see you. Thank you very much.
Thank you.
For trying to help us explain all the ins and outs of these laws.